Hello, Lyric Armstrong, your real estate agent, advocate, and certified paralegal commentator, right? So I'm here because I'm vested. But I want to think out loud and see what you think. Um, so Brian Steele said, okay, so finally, okay, Ben Steele is Ben Chu and Brian Steele. So if anyone didn't, it took me a long time to clear that up. I keep confusing Brian's name, Ben, and so I apologize for getting his name. What did they say? 40 and slip? I don't know. So he is in fact Brian Steele, and I think he's in good company when compared to Ben Steele. I Ben Chu. I don't think Ben deals with criminal law though, right? So anyway, I was paying attention, and one of the followers did a great job of saying, "Hey, did you see how the guy in the middle was like shaking his head for during the status conference because Judge Page was like, hey, think about settlement, think about plea deals, like kind of talk about that, talk about that. This is a great time to handle that. Um, I will step in the way. You have my blessings to move forward as you see fit. Very encouraging of closure, right? Because closure needs to come to this case. And so shout out to our new member who was gracious enough to speak to their opinion, and that would be Michael Lauderdale. So Michael Lauderdale dash YR9OM Yeardom. I'm not sure what we're supposed to, but thank you, Michael. We definitely appreciate your perspective. And shout out to Peggy. She's been a great member, and I love comments. I love them. It helps us to talk, right? So talk with me. Tell me what's up. So make sure you give your comment, your opinion, and we would love to see and hear from you. So unlike YSL case, we're not going to hold your First Amendment right against you. Even if you're not an American, you still have the First Amendment right on this channel to have your opinion. So as long as you're respectful, you can go ahead and exercise that right. So anyway, let's get into where Brian, well, we can get into some of the law that he quotes in a minute, but I want to get to the spot where he's talking about it. And I'm going to beg, plead, and want every single member who is you don't have to be from Georgia, but criminal attorney or criminal paralegal with some, good experience, 10, 15 years or more. Tell me what you think about this spot that Brian has put up. Mr. Steele is ready to do a motion. Of course, when the motions come out on Monday, we'll be able, or Tuesday, I think Tuesday's the deadline, we'll be able to have more details. But just preliminarily, if you were getting ready to draft this motion for the attorney, if you are the attorney and you're drafting it for yourself, how do you feel about what Brian has to say right
now? The copy of the case that I've handed to this honorable court and the state on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor, may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially denied, he stopped proceedings and he denied that motion without referring to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes.
Was there a written order?
He did file a written order June 14th, okay. 2 days later.
All right.
And that was the Honorable Douglas one. Okay. The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. This is Monday, June 17th. Okay. But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted, Judge Krause in a written order dated, I'm going to tell you.
Okay, so here's
Judge Krause in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then.
Okay. So yes, we do need Brian to do that favor, because here is where I am. And I kind of talked about it there as well. So that's why I was going past me to hear that twice. But what I am concerned about is, let's go back in, unnecessary court. Let's get into some of the quoting that he did. All right. So what he quoted, I went to case text and determined the name of the case that he's quoting is called Pross or Pro. I don't know what the thing is, versus Morgan. The citation is 288 Georgia 862. So that's the citation. And he begins the quote here. This is what he quotes in terms of the legal standard in the case law. So this is by case law. As we know, law is developed in a couple of ways. We voted into law as citizens after getting a petition to put it on the ballot. Another way is, we have our codes that are statutes that, are already in place. And then we have case law. In case law, I said that's trial court does not make the law, because trial court is implementing the law that has been made in either forms, whether it was voted in or the case law came about or the statutes and codes represent the law of the land. Now, case law is an instance where you have something that goes through trial court and someone appeals it, right? There's a decision made and they appeal. And the appeals process is very strenuous, and it's typically, mostly, if not always, based upon the technicality of how things flowed. So you have an objection that's overruled that should in fact be sustained, you would appeal based on that. Several of those. However, just because it should be sustained does not always mean that the case itself needs to be retried or that it's a mistrial. So it has to be of a high standard for the Supreme Court to say, stop the case back down to the trial court and say, do this over because doing it with this procedural activity is incorrect. Or they say, you know what, this was so far away from fair and impartiality and justice could not be served because this is tainted. This case is a miss. So we overturn, reverse whatever the decision is. So to get to that point, you have to have a conviction. The clients have to have enough money to put up the bond, to actually appeal. It's a process. It's a financial commitment, and it's extreme. One of the things that Weinstein asked for was a certification, and the certification, or whatever, I think it's called certification, but it was to help expedite the circumstance because the issue was such a major appealable issue when his recusal motion that he wanted it to be seen by the appellate court immediately versus waiting till the whole case got resolved. And Judge Glanville said no, because that stops the case. Weinstein says that stops this case. His representation, I believe, was in error because obviously it puts a pause on the case. You can't do anything. The whole purpose is appellate court. You need you to look at this. This is an emergency because we're trying to have a trial, but yet we have this major appellable issue that could in fact change the outcome, or it has a major impact on the potential outcome of the case. So Judge Glanville denied that, right? Then he had his motion to accuse Judge Glanville. He denied that as well. He denied it on the surface of it. He said it was timely, and it met the three points. So here's the thing. I'm thinking out loud, and I want every legal-minded person to think out loud with me. So help me here. This is what Brian just quotes. Another line of appellate decisions holds that, meaning this is like them saying, this is our judgment, this is our order. We hold that, this is the belief. If a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and of no effect. I understand this statement. This is a statement that comes from this. So the quote that Steele gave, the case that Steele gave, he's quoting another case. So it's Gillis versus City of Waycross, and this is in Georgia. Statutes and judicial codes of conduct that govern recusals serve to maintain the integrity of the judiciary and the rule of law. Of course, that's understandable. By requiring disqualification, for example, where a judge's bias is of such nature and intensity to prevent the defendant from maintaining a trial uninfluenced by the court's prejudgment. Thus, the rationale for invalidating the decision of a judge who should have been disqualified is that appellate court's litigants and the public simply cannot have confidence in the rulings of the judge in that case. I don't want to download that. So my issue is maintained because if Brian Steele wins this motion, he is saying that from the point of Weinstein's motion to recuse that was denied in the courtroom June 14th, sometime around that time frame, he's in the middle of Copeland's testimony. Mr. Copeland has testified, and he gets so far as to plead the fifth to his date of birth. And the cute part about that is what's criminal about it. Like I said, if you're not in a child endangerment as a kind of, thing where your age plays a part, how in fact can you plead the fifth? Because pleading the fifth is the amendment number 5, or the Fifth Amendment, which is protection of self-incrimination, protecting yourself from walking into disclosing incriminating factors. And it's usually, question by question basis. So consequently, your age did not play a part, and he's grown. So he gets down, well, I'm grown. Yes, he's an adult. He's over the age of 18. So it was like his way of putting a stance that he does not want to be here. That I think was more of his point of pleading the fifth, especially at that particular time, that he's being forced to be here. And then that becomes a whole debacle, right? So we know what that is. Brian's motion, when he files it based upon what he introduced us to today. Was that today? Yesterday, whatever day it was. He introduced it to us as this is a motion being refiled. And Judge Whitaker says, okay, all motions filed by Tuesday the 23rd. At time of hearing his argument, it's like, we're reaching. And it's good because he's supposed to reach. He's supposed to do above and beyond for his client. It's a part of his zealous advocacy. It shows his commitment to try all potential and viable arguments. I am just concerned because tell me, what do you think? Was the judge disqualified to act in the case? And I think there is an inherent theory to say, well, he was recused, so therefore he was disqualified to act in the case. Okay, I might can follow you there. However, I am concerned further because the example is that the required disqualification is where a judge's bias is of such a nature and intensity to prevent the defendant from obtaining a trial uninfluenced by the court's prejudgment. This is something where I said before, does the prosecution have a provable case? And now to the defense, do you have a provable motion? Because they don't have to prove the case, but they do have to prove the motion as a moving party, right? And it's questionable to me because in Judge Krause's recusal, she excuses Judge Glanville's behavior. The major question of the motions was Judge Glanville's biases. Having an ex parte hearing was coercive. It was, he was a sworn witness, so it was out of proper dealings. And, we realized that Judge Glanville put up his argument that it was an emergency situation for security purposes, but yet in the transcript, there's not much security spoken of. So in the findings of fact on Judge Krause's motion to recuse Judge Glanville, I want you to take note of this. June 7th, already up, is it up? Up. Let's make it bigger. June 7th, the state intended to call Copeland to testify. This is that Friday. Prior to his testimony, counsel for Copeland, which was Melnick, at the time, this is before Bumpus became the stand-in, Melnick appeared and indicated in open court that Mr. Copeland did not wish to testify and intended to invoke his Fifth Amendment privilege against self-incrimination. Judge Glanville brought Mr. Copeland into court and discussed with him the effect of an immunity order that Glanville had entered that granted immunity to Mr. Copeland. Glanville specifically advised Copeland that if he invoked the Fifth Amendment and refused to testify, the state would ask for Copeland to be held in contempt and jailed. Judge Glanville advised further that if asked, Judge Glanville would jail Mr. Copeland for refusing to testify. So these are elements that just say he was forewarned that if he pled the fifth, because he already pled the fifth, he was forewarned that if he pled the fifth, and if the prosecution, the state, wanted him jailed for pleading the fifth, the judge would apply. After such discussion, Copeland spoke to his attorney and then indicated he would testify. Once called, Mr. Copeland was asked to specify his age, and instead of answering, he stated, I plead the fifth. Okay, so that is on the Friday. So after excusing the jury, Judge Glanville once again explains in open court to Mr. Copeland, who is the witness, that he was in contempt and ordered him to jail until Monday. So he could think about it. Do you really want to go down this road? Do you not understand what's happening? On Friday, the 7th, this is still happening. Melnick spoke to Copeland and reiterated to the court that the witness still intended to revoke his Fifth Amendment right if he was called. So he was already sworn in, he was already a witness, he was already called to the stand. So basically, if he was recalled, he had to go back up to the stand. Judge Glanville indicated that he would revisit the issue with Copeland on Monday and that the day was adjourned. Okay. So that's a bit of how we got to the rabbit hole. I want to see the other. Now, this is where So a part of the language in the finding of facts, it just like I said, it washes Glanville's hands. It makes things look more restrained and professional than they actually played out on YouTube. Okay. So we understand that judges don't want to come up, colleagues don't want to come up against, they don't want to hang each other, not unless you're trying to get them off. For the most part, colleagues are pretty protective of one another. Okay, so here, Judge Glanville announced on the record that the motions were timely and supported by an affidavit. This is the motion to recuse. In transferring the case to another judge for consideration, Judge Glanville necessarily determined that the third criteria was satisfied. And the third criteria is that recusal might be authorized if the facts alleged in the motion are assumably true. Okay, we can get to that a little later and refresh our memories of that. Glanville was required to refer the motion for reassignment and was prohibited from opposing the motion. It is worth noting, this is the love letter. This is the parachute. This is Glanville's saving grace. And this paragraph, mostly this paragraph, is where I wonder if Brian Spiel's motion will have any legs. I think it would if, in fact, the recusal was based on Glanville's actions with an ex parte hearing. The recusal is not based on that. The order to recuse is based on the fact that he was prohibited from opposing the motion, and he did so anyway. So this is the get out of jail free card for me in terms of why I felt like Judge Krause was very overly protective. And we know why. One, it was protected from the fact of going up on appeal because the motion is granted, but it's almost as if the motion is granted not even in part, but just to technicality. The motion is granted due to technicality, not because of biased actions or improper litigation procedure. So here is the paragraph. It is worth noting that this court agrees generally with Judge Glanville's assessment of the propriety of the ex parte meeting. While the meeting could have, and perhaps should have, taken place in open court, nothing about the fact of the meeting or the substance discussed was inherently improper. So this line right here, this phrase right here, is almost death to me. It's almost death to the motion for which Brian is going to file. So I'm looking forward to how he's going to overcome this, because this is the order that Judge Krause gave. She gave in one part, hey, what Judge Glanville did with the ex parte meeting was, in general, A-okay. And maybe it should have happened in open court, but nothing factually in that meeting or substantively discussed was improper. So it wipes those hands clean. It in this order, it okays the ex parte. It okays, the meeting, and it stated, in my opinion, improperly states, but it states that there was no substance there. So, furthermore, however, in this order denying Kendrick's motion and in the process of making his record on July 1st, Judge Glanville added facts, providing context, questioned the veracity of allegations, and otherwise explained his decisions and actions, and argued why those actions were proper. This action by Judge Glanville, this is what is the technicality. This is what gets the recusal. So while it may be appropriate for the judge to disclose information relevant to his potential recusal, such as disclosure must be made in a way that is objective, dispassionate, and non-argumentative as possible, so that the judge is not reasonably perceived as hostile witness or advocate. And this is based on the case, Post versus State. This is the citation in presenting his record as to the recusal issues and in the ruling on Kendrick's motion. This is Judge Krause coming back in. This information here in the quotations is a cite, is an actual quote from this. Judge Krause says, in presenting his record, meaning Glanville's record, as to the recusal issues and in ruling on Kendrick's motion, Judge Glanville evaluated and accepted the truth of his own factual allegations mandating his recusal. So that is why, because the court has no doubt that, oh, here's another thing. This is another part of Judge Krause's order. that washes Glanville's hands when it comes down to the ex parte meeting. The court has no doubt that Judge Glanville can and would continue presiding fairly over this matter if the recusal motions were denied. But the necessity of preserving the public's confidence in the judicial system weighs in favor of excusing Judge Glanville. This is why I called it giving him excuses, because all they did was excuse him. It wasn't a recusal in the sense of, hey, Judge, you did wrong. That was wrong of you. You were recused from your duties. It was you weren't wrong in having the hearing, but since you defended yourself, technically that's a problem. So we're going to have to excuse you of your duties. That is the complete difference of tone to this particular motion. So consequently, Judge Glanville is excused from further handling of this case. And this court hereby orders Defendant Kendrick's motion to recuse is granted. Caleb Bump's motion to quash is denied. Defendant Jeffrey's motion to disqualify / recuse is granted. So here is where the best parts for Brian Steele. I want to get green on it. Let's get green on it. This is good for him. But these are the titles of the motion. And the order substantively agrees that the ex parte was proper. The order substantively states that Judge Glanville would be able to continue to be fair in his presiding over the matter if the recusal were denied. So the only legitimacy that Judge Krause gives to the motions that are granted here is the fact that he needs to be recused because he defended himself against Post v. State's order. Because you have to have non-argumentative as possible, so that the judge is reasonably perceived and is not presented as a hostile. Sorry, I lost my place. Anyway, because when the judge has a motion to recuse and it meets the 3 merits, then if the judge goes into defending or responding, you give a presentation that you're advocating or you're sounding much like a hostile witness. And so consequently, both said no response from that judge. You take it and you send it off to the next judge and let them decide upon it. So these are some of the things where I'm interested. Very interested on the legal parts of this. This is like the legal nerd moment that I really, really want to know about, because when I say it's hard to have legal minds to agree, this is where we're going to see if the judge will agree, because I don't think the judge will. And I haven't even seen Brian's argument. I haven't seen his motion. So hopefully he has good salient arguments that can be upheld up against some of these cover-ups, for lack of a better word, but definitely washing of the hands that Judge Krause did on behalf of Judge Glanville, stating, as I've highlighted here, nothing about the fact of the meeting or the substance discussed was improper. That is a major blow, because the ex parte hearing could arguably have Brady violation. And the judge does not get into those specifics, but she does a wiping of the chalkboard by saying nothing was problematic, right? And the only problem was that Judge Glanville took it upon himself to give defense or excuse or reasoning when he was not supposed to say anything. So when everyone runs down to the last page, this is the last page, right? Yeah. Everybody runs down to the last page and they just hear, because this is what we always do in the legal field. We always go to what's, last page or two, what's the order? Granted, denied, granted, denied. We want to see what it says. Then we go through the formal pages. But this is deception. This is deceiving. If you're not reading the whole thing, you feel like, yay, finally, someone has listened. Someone's paying attention. And I guess what? It's not you. If you didn't read the whole 10 pages, then you didn't pay attention, because this is very deceptive to say, based on the foregoing, this court hereby orders as follows. The foregoing is all of those 9 pages. And what it has stated is the misstep of Judge Glanville is the defending of his actions of the expert. After the motion to recuse was being transferred over for Judge to see. When the motion to recuse came down, he was not allowed to defend himself. When it came to Brian Steele's inquiry, when Brian Steele's like, hey, how did we get here that the witness is not testifying? Because you said we were going to hear about some things. We had to spend 2 hours and we're just jumping into conversation. And quite frankly, I heard that there was some meeting that you guys had without us. I don't know if this, I'm not sure it's accurate, but Judge, honestly, was is it true that these things happened, that this was said? Did you have this meeting? And the judge could have very well said, yes, there was an ex parte hearing. I'm not sure why you are informed about the particulars, but due to the emergency nature of the ex parte, the emergency nature of the witness's security, an ex parte hearing transpired. The sum and substance of that meeting is meant to be protected. It is not meant to be disclosed. And then still could have said, but you can have an ex parte meeting with a sworn witness. I can under the emergencies. Here is the proof of that. It was an emergency relative to the security. Had he expressed during that time frame his reasoning for having the ex parte hearing, had he done his other position of informing the defense as he was supposed to of the ex parte hearing, then that would have been perfectly fine at that time. But because he started defending himself in his action, I don't know what to tell him. Because he defended himself in his actions after the motion to recuse was filed, and it met the threshold, therefore it was being transferred to the other judge. He was not to say a thing, and he did it anyway. So that's the foregoing. But understand, based on the foregoing, is based on him talking when he wasn't supposed to, not having the hearing, not the substance of the hearing, not the impropriety of the hearing. In fact, the judge Krause stamped it proprietary. She stamped it that it was meant to stay away from the other side. So I don't know if there's going to be, I don't know if there's going to be potential backlash to Madam Bumpus in any terms of trying to get her disbarred or dealing with some type of reprimanding from the bar. But this order gives wind that disclosure of the sum and substance of the order is problematic because the ex parte hearing was considered, based on this order, was considered proprietary. So she confirms that the meeting was proprietary. And she kind of loosens it and says, well, maybe it should have been an open court, but it didn't have to be. And she kind of, she excuses it. And just because she says defendant Kendrick's motion to recuse is granted, and Jeffrey's Williams' motion to disqualify / recuse Glanville from all further dealings in the above referenced cases amended and supplemented is granted does not mean it's based on the merits of those motions. It means that it was on the technicality of the argument. So Brian may be able to say, you granted Kendrick's motion. So therefore, based upon the timeline of his original motion, all the dealings thereafter need to be erased. But I'm wondering if prosecution is going to come back and say the granting of Kendrick's motion was based on the technicality of Judge Glanville defending his procedure, but in the order in and of itself, there was no impropriety in the ex parte hearing. There was no, what else I should say? There was no, the substance of the meeting was not improper. And so, and the necessity of having the meeting ex parte was not problematic, or the way she put it was, I'll say it. She said it could have been an open court, but it didn't require open court. And so it gives a lot of room for the reply. Judge, not Judge, Brian Steele, it's going to be interesting. It's going to be interesting to hear and to see what he has for this motion, just because we know that this order is very forgiving of Judge Glanville, very forgiving. I think the only thing that it just couldn't forgive is that he made those statements. Had he not made those statements, it probably would have forgiven all of it. So that's why, maybe not, but that's why I wonder if he made the statements on purpose. Because by the time he started making those statements, nobody cared. Brian is like, I'm gonna call you as a witness. You are a witness. I don't care anymore why you had the ex parte. I want to know what's in the ex parte. So that is very interesting. I'm very interested in how that will play out legally. And realize, people, everybody should be concerned about what goes on in court. Everyone should be concerned about what voting rights you have, what legal rights you have. We all need to be concerned about that. Whether you are legal or just interested because you are a YSL friend, or you enjoy their music, whatever it is, This is like everyone should be concerned. Everyone should be paying attention at this point. I know it doesn't. It feels like, why do I want to consume myself? But especially for those in Georgia, you kind of need to know. And then I thought about it. I said, how great of them to be able to stay away from this case as jurors and as a judge. But I also wondering, why is there no news coverage of this case in Georgia? You know, it's got to be, right? We have to be talking about it. Okay, so here is the transcript. We went over it a great deal, because we went word by word. We didn't just take anybody else's word for it. We read the words word by word. So that's in a whole different um, video. So check it out if you care to go over it word by word. But the hearing began at 19 a.m. Those in the beginning, this is before Copeland comes in, were accounted for as Judge Glanville, ADA Love, Attorney Bumpus, court reporter, and investigators, Long and Hamilton. Court reporter confirms she's ready. ADA Love thanks the court reporter and states to the judge, the concern that we want to bring to the court's attention as the state was twofold. She is twofold, but she said what? Number one, and I can't highlight this one. Why can I highlight one and not the other? Anyway, one, we want to have the opportunity to impress on Mr. Copeland with representation present that he faces. And we wanted to give him an opportunity to ask whatever questions he wanted to ask before he was we had to pull him in the courtroom when the jury came out. So clearly there's a lot of hints going on here, not really complete thoughts and sentences. But I always took issue with the fact that the first thing that she wants to do, ADA Love wants to do, is impress upon Mr. Copeland. I have felt, and maintain the same feeling that, maybe this one right now, right? Oh, it's only that impressing upon Mr. Copeland is a nicer way to squeeze him, a nicer way to get him to testify, coerce him, a nicer way to make him feel the highest necessity to testify, even though he has expressed on a number of occasions he only wants to plead the fifth and he doesn't want to testify. Okay. So that's her number one concern, is impressing to this witness with representation present that he faces blank. And we wanted him to have an opportunity to ask her questions he wanted to ask before he was sort of blank. We had to pull him in the courtroom when the jury came out. These blanks might be a pause in her thought because she's being careful with her words, but this right here expresses to me that he faces jail time, the very thing that he doesn't want. And with representation present, meaning with his counsel there, we want to give him the impression that, or give him the information that is necessary for him to testify, because otherwise he's going to jail. And this is what they do for pages and pages on end. That's her very first concern. These are the list of the state's concerns based upon their own words. They have two concerns. The first concern is impressing Copeland. What happens if he doesn't testify before he goes out to the courtroom and is before the jury? And that's not problematic as far as like before the jury. It's problematic that it's without the defense. That's the problem, because he's a sworn juror right now. I think that would be a better motion to have with the defense present, maybe Copeland present, just to kind of talk about, Copeland needs to understand his immunity deal. We want to make sure that his new attorney is informed of what that deal is. Please give him the information. I think that could have been done under seal, if you will, so that the public is not involved, because his immunity deal is meant to be under seal, but the defendants are supposed to get a copy. If they're allowed to know what's in the immunity deal, there should have been no problem with them being a part of the ex parte hearing with the sworn witness. Now, the second concern that the state has is, and I wanted to bring to the court's attention in line with the concern that I expressed on the record on Friday, I don't know what advice counsel may have offered or may be offering. That is their right and their business. As it relates to testifying, however, I do not believe that criminal exposure is a concern which an interest is being spoken about and protected. Mr. Melnick relayed to Mr. Hilton on Friday that he had not heard of the statute 245507, and on Friday he sent an email. I don't know if he intentionally copied Mr. Steele and Mr. Shard. I don't know if he unintentionally put his name on it, but he sent an email to Mr. Steele and Mr. Shard with me and Simone copied, stating, "This is the communication that I received from Ms. Love regarding Mr. Copeland." My response was, "Whose interest are you protecting? Whose client?" He wrote back and said, "You are going to get him killed. You are making him a target. F you," is what he wrote in the email. So my problem with the order that Judge Krause put in was that the ex parte hearing was fine and that nothing improper took place. Well, the ex parte hearing, and she doesn't validate that in any way. The email is not attached. Hearing from Melnick on YouTube, he believes the email reads differently than what is purported right here. It sounds as if she is paraphrasing the email. But this is her secondary concern. Her secondary concern is that pleading the fifth is that Copeland doesn't have any criminal exposure because of his immunity deal. So therefore, there's no need for him to plead the fifth. Excuse me. And she may feel as though, and I'm being as lenient as I can because it's not stated here. She may feel as though is that Copeland is pleading the fifth because Melnick has told her that you are going to get him killed. You have made him a blank. You are making him a target after you. Is what he wrote in the email according to her. And what he says is kind of missing in this paraphrase is, how dare you question who my client is? My client is Copeland. And then how dare you ask, who am I representing? Whose interest am I protecting? You know, is it Copeland or is it Steele's clients? Why are you giving them this communication between you and I? And he's saying, how dare you? My client is my interest, and the things that you are doing to him are against his interest. But because Melnick puts in, you are going to get him killed, that is where the emergency of the ex parte hearing possibly has the excuse. And that's what I said in the beginning when I read this transcript the first time. It's like, I think that is where they're going to hang their hat. But what Judge Krause does is she just says, oh, everything's A-okay. She does not validate that with the email. So the precise wording of the email is not in evidence. We don't know what it is. We don't know if that's exactly what Melnick said. But I think he doesn't deny it, if I remember correctly. So she furthers with her second concern. So given that concern, is that by testifying, at least the one that he conveyed to me in writing, it's not his concern has anything to do with exposure from the state. And if he is concerned, the court is being whose concern? Ms. Love, Mr. Melnick. So I think that's an improper response because she's speaking to Melnick's concern. Well, Melnick is not the witness, right? So we've got to, so the court ex parte hearing needs to know, Copeland, are you in fact fearful of your life? Do you in fact think taking the stand would in fact harm you or have the potential to put a target on your back as so suggested by your own attorney? Those questions are not in here. None of those questions are in the transcript for the ex parte hearing. That is concerning. So Love goes on to say, if the interest that he is protecting, Melnick, if the interest that Melnick is protecting belongs to Mr. Copeland's freedom, he did not convey it by asking us what exposure does he face in testifying. These are like fast and loose words. Protecting Mr. Copeland's freedom. I don't know. Maybe she's speaking to the immunity deal. Maybe that's what she's speaking to. Because the immunity deal keeps him free and protected from criminal exposure as long as he testifies. But she's stating that she's confused about Melnick's potential protection of his client because he didn't convey it that way. In fact, he conveyed a concern that the testimony or the testifying process for the witness may get him killed, and he is not communicating with us. He's communicating with counsel for defendants. It would seem that he knows a thing or something that we don't know. Speculative. And he should know. The defense should know something you don't know. Because you know why? The defendant has the right to remain silent. Anything you do and anything you say in the presence of the officer or in the presence of the officer's camera or in the presence of the recording or without your attorney present can be used against you. in a court of law. So with the Miranda rights, a defendant who does not disclose or talk to you and invokes his right of staying silent and having an attorney present, then the attorney knows what the client knows. And prosecution, it ain't none of your business. That's what we call attorney-client privilege. So yes, he should know a thing or two that you don't know. Yeah, that happens. It should happen. That's the point. That's the point of representation and attorney-client privilege. That's the point. Additionally, I'll let Ms. Bumpus tell you, he has said if Mr. Copeland testifies, he's no longer representing Mr. Copeland. So now she's extorting Melnick and Copeland's agreement that Melnick will not represent Copeland during his testimony. And this gets sifted out because basically Copeland doesn't want Melnick's representation or Bumpus's representation because he wants exposure to what the state has put him through. And a part of that exposure is that he has, and this is why Melnick says he can't represent him if he testifies, is that the state has had conversations with Copeland without his attorney present. And that is a bad act on the state. That is improper on the state. That is proven in this order. But yet, this order, in this transcript, but yet Judge Klaus's order does not address it. It does not address any substance in here. It doesn't address the fact that her first concern is to impress upon the witness that he can be jailed, as if he wasn't already told this, and put in jail. Like, he knows this. The judge told him this in open court. So why would you need that to happen in ex parte? What's the point of that? Why do you have to have a private meeting to impress upon the witness that he could be put in jail for pleading the fifth when he's already done that in open court and proved it by putting him in jail that very day? So, and then the secondary concern that they have has to do with the emergency exception. Potential emergency of security for this witness is a exception to why the judge would have an ex parte hearing. It's secondary in the statement, and it's very lucidly spoken about within these multitude of pages of transcript. And I think it's not even Love, it's Hilton who makes mention, and Hilton makes mention when she says, how she put it, she says, she says, we don't know anything about them. If you, so here's the, okay, I remember Ms. Hilton, I said this before, this is page 48, so it's 50% of my pages of this document. And Ms. Hilton says there's no, we keep on saying yet, but there is no crime. We keep on saying yet, I don't know who is telling you about a crime. There is no crime. You have done nothing wrong except for not, so why am I in jail then? Because you aren't testifying. So she says these words yet, line 21 to 22 on page 48, but that's it. So that's why I say this is an incomplete transcript. But they certify it's complete. Actually, I don't know if they certified it's complete. They've represented that this is a complete transcript. So I want to get back into he maintains that he had told her, oh no, she's saying he didn't say this, and he says yes, it did. He told her for days on it that he was not going to testify. He wanted to be with that. I want to get into, this is where they talk, this here is where they're talking about inconsistent statements, but yet they will use the inconsistent statements only for impeachment, not to jail him. Oh. I'm looking for Hilton when she says, I'm looking for when Hilton says, okay, here's another thing where that's the court. There's also another time when Hilton or Love says to him, oh, Your Honor, you should close your ears because if, I just want you to know, if you committed a murder and you confess to that, if I don't have corroborating evidence outside of you testifying to committing a murder, then you're immune. This is your immunity deal. It's a full immunity. real quick to highlight the fact that I had said, why in the world is the state bringing up a witness just to impeach him, to impeach his credibility, to say that he's a liar, to prove that he's a liar? Listen, Miss Hilton is quoted as saying, well, Miss Bumpus inquires, you can charge him with false statements and he will be back in jail. That's what I'm trying to say. She's trying to, because Hilton is like, don't worry, the immunity deal has you completely immune as long as you get up there and testify. And the judge says, yeah, you have to get up there and tell the truth, tell what you know, tell it as you know it, and you'll be fine. And Hilton's like, well, he's like, well, I don't remember what I told the detectives because I lied to them. And Hilton goes, that's okay because I'll just impeach you on that. That's not a problem. So Bumpus is like, but if he has a false statement, you're going to put him back in jail. Like she's trying to ensure that the client is informed that even though you have immunity, if you start, lying, or they think that you're lying, or they know that you're telling the truth and untruth, they're going to put you back in jail. Immunity, you're not, because you're not immune from lies. Hilton replies, but if I know that you are lying about that, what is that? If I know that you're lying about that, I do not intend to do that. So the thing about attorneys is attorneys are fluent in the English language, and they are fluent in legalese. And a part of the English language requires identification of the word that. This sentence does not identify the first word that, and it also does not identify the second word that. So there's a lot of in between the lines talking or some lines missing. That's how I feel about that. And she goes in to say, if I know right now he's lying, I know he's lying, I'm not going to charge you because I don't know your reason for doing that. You don't know your reason for doing what? Lying? So if he's lying, you're not charging him, even though you have the responsibility ethically to put up a witness who's honest. But if you know, or that you believe is honest, but if you know he's lying, you're not even going to charge him with it. But I'm not going to charge you when I know you didn't do what you are trying to say you did now. And that could be part of this. I know you didn't do it, but it's up to the judge to do that. So, no, it's up to the state to bring charges. So she knows he didn't do it. Let's get back to what I was looking for. Just to be fair to her definitions of that in that what I just read, it may be because she might be referring to Copeland saying like murder. In the instance, she says, if you say something that you know you did not do, like you admit to something you know you did not do. And he says like murder, because murder doesn't have statute of limitations, right? So if I admit to murder, would you then arrest me for that? And she gets in, but if you didn't do it, I can't charge you with something you didn't do because I don't have any other evidence but you saying it. And so that's her saying, I would need cooperating evidence beyond just you admitting to murder. And so, what y'all don't like, Bumpus gets in, you could charge him with false statements. And she goes into, yeah, but if he's lying about that, which most likely is murder, I don't intend to do that, which is charge him with false statements. So that would be the best definition that I can give to those words that, even though it's up to Madam Hilton to speak clearly and articulately as to what she means. So right now I'm speculating as to what she means based off of what the transcript said. Here's another sentence that I think people overlooked when it came to the potential Brady violation of keeping this ex parte hearing out of the defendant's purview, is that Mr. Copeland is pleading with them that he is allowed to plead the fifth. And he's telling them, I won't plead the fifth to things that don't incriminate me. He's saying for all the things that incriminate me, that's where I will plead the fifth. And the court comes in and starts giving him all the reasons why he can't plead the fifth. He has an immunity deal. He's an important person, so he can't do that. He has to tell what he knows, say it, whether it's good, bad, or indifferent. And that he's now endorsing what the prosecution is saying. Ms. Hilton is telling you is just tell the truth as you know it and let her worry about. I mean, even though you may have said different versions of whatever, that's for impeachment. That's not going to get you in trouble. So he is advising Copeland, listen, you have an immunity deal. You get up there and tell what you know, no matter what it is, whether you think it's going to incriminate you or not, good, bad, or indifferent. And if you feel like you've made other statements that contradict what you're getting ready to say, don't you worry about that. Let Hilton worry about it. She'll deal with that during impeachment. Yeah. So Judge Krause, all this is right. This is good. This is all legal, right? This is no problem. Another interest for the defense. Copeland has, I done told them whatever different story I could think of to try to finesse my way out of the situation. I don't recall what I done told them. Ms. Hilton says, well, then just say, I don't recall. And that's in response to his encounters with police questioning him. This is him once again admitting that whatever he said was to finesse it, was to finesse him out of the situation. Then you have him later saying, um, I want I want to plead the fifth to the things that incriminate me. Yeah. So he has told you he finesses his way out of his situations with the police, gives them whatever story they need to feel better about themselves and leave him alone so he doesn't go to jail. He says that pages above. To plead with them, he wants to be able to plead the fifth to questions that he feels will incriminate him. And he pleads with them again. I won't plead the fifth to things that don't incriminate me. I want to protect from my self-incrimination as a Fifth Amendment right. Here's another interest of here's one of the major interests that I was looking for when it comes down to the defense. It's on page 30 of the transcript, line 22. Mr. Copeland speaks. You said, and this is him going back and forth with Hilton, expressing that it was days on end that he kept telling her that he was going to plead the fifth. She denies that. And he says, yeah, I did, because you started talking to me about why would I want to do that. And so he goes into that. You said, Hilton, why would I plead the fifth to something I didn't do? And I said, Copeland, you don't know what happened. So Copeland is saying in more ways than not, you don't know what my true involvement was. One, because the things that I have told the investigators, the police officers, have been multitude of lies, and they're going to be inconsistent statements because I lied, and I did that to keep myself out of jail. And I'm telling you, I want to plead the fifth because I want to avoid incriminating myself. And I don't want to have to be told I have to get on the stand and tell the truth, because if I tell the truth, I'm going to be held for charges on that. And she's telling him, no, you're not, because that would be impeachment of prior inconsistent statements. And Bumpus is like, but that's a false statement. If you think he's lying, then you would arrest him. No, I won't. I won't arrest him for that. And he's saying, look, I want to plead the fifth. And as we saw later on, he goes, just let me plead the fifth to the things I know that's going to incriminate me, and I'll testify to everything else. And it's like, no, you have to testify to everything. And he says beforehand, I told you that. I told you I wanted to plead the fifth. She says, no, you didn't. And Mr. Copeland says, you said to me, basically in response to me telling her, you said in response, why would I plead the fifth to something I didn't do? And I said to you, you don't know what happened. And so right before same page, top of the page is where the major breakdown is for the Brady violations. The Brady violations, of course, is that which the defense can use, anything that the defense can use to help defend themselves against the case. And also it hinders their preparation of how they're going to object to a witness on the stand and how they're going to cross-examine a witness on the stand when you keep certain evidence away from the defense. And they kept this evidence away because this is his testimony. And one of the issues about the ex parte hearing is the ex parte hearing was only meant to be an emergency for his security, to handle security concerns, not to get into his testimony because he was a sworn witness. All throughout here, you can see him talking about his testimony. You can see him pleading for being able to and trying to negotiate even when he can do the Fifth Amendment protection, because he feels as if he's implicated in these charges. This is truly his feeling. This target on his back, this emergency for security, it doesn't flesh out in this order. I mean, in this transcript. But this is where the whopper comes in. Let's see, we can start. I don't really know that far back. So just basically, Hilton says, I did not do it. You did it by pleading the fifth. So he's saying, you put me in jail. You put me here. You did this to me. And she says, I did not do it. You did it by pleading the fifth. And Mr. Copeland said, you told me before you went to the judge with whatever the thing called, which is the immunity order, you went to him with, you told me that I can't, when I'm asked a question, I can say I don't recall or I don't know. You told me that if I pled the fifth, I mean something. Why would I plead the fifth to something I ain't do? And I said that you don't know what I did and what I ain't do. And then you was like something. And then y'all asked for this immunity. And I was like, it was something. And then Thursday or Friday came, and then y'all go tell me, oh, we went to the judge with this, so you got to testify. If you don't testify, the judge gonna lock you up. Ms. Hilton, right? But that was based upon what I told y'all that. Ms. Hilton, no, you didn't. Mr. Copeland, you said, why would I plead the fifth to something I didn't do? And I said, you don't know what happened. Here's where Melnick gets into why he doesn't want to be a part of him testifying, because you admitted to doing this. You admitted to having conversations without his attorney present. You say, Mr. Copeland says, oh, wait, Ms. Hilton, let's see how far back you go. So, Mr. Copeland, I told you every day I was pleading the fifth. Every day I talked to you, I told you this. Ms. Hilton, no, you didn't. And we told you, which is like really unreasonable, because she admits to saying, well, why would you want to plead the fifth? And he says it over and over again. We talked about me pleading the fifth because you responded by saying, well, why would you want to do that? It's something you didn't do. And he finally responds to her, you don't know what I did. You don't know what happened. So there's very reasonable thought process with what he's saying versus what she's trying to put on the record. Mr. Copeland says, I told you my concern, Ms. Hilton, and we said we could give you immunity. I told you my concern. His concern is being locked up for the crimes he has committed. His concern is not safety. And we're here, and he's reiterating this on page 28. I told you my concern. And she responds in acknowledgement that his concern has to do with his criminal exposure. She said, and we said we could give you immunity. Based upon his concern, we could give you immunity. You said your concern is what they know about you. And when you said that, I said, well, you know stuff about them. I guess this is the defendants, they and them, once again, undefined. And then I said, whatever your concerns are, we can give you immunity. So now it makes it sound like they and them are the police, not the defendants. See how easily words can be misunderstood when you don't use full sentences and you sit up here and speak in code and poor English in that regard. Like, who is them? Them who? Mr. Copeland. So I didn't tell you I lied on them to get myself out of the situation. Okay, lied on them. Is that back to the defendants? Ms. Hilton, you said you were a liar. Oh, did he now? So did your star witness tell you, Ms. Hilton, that he's a liar prior to you mandating that he gets on the stand? It's a lie. That's what you said. You said you were a liar. Ms. Bumpus, was this recorded? Ms. Hilton, no, no. Oh, this actually went back further. Ms. Hilton, you and I had this conversation on Friday morning, Mr. Copeland. You knew my child's birthday was next week. Okay. So this is a conversation they had on Friday morning. And so Ms. Bumpus says, well, was this conversation recorded? No, no, it wasn't. Ms. Bumpus, and did he ever say that Melnick was his attorney? Because Ms. Bumpus is getting into, why are you having conversations with this witness without his attorney? And Ms. Hilton said, no, this week, when we first met you in the car on Friday, I guess she's speaking to Copeland, we asked you, is Mr. Melnick your attorney? And you said, he's not my attorney. I haven't even talked to him. Copeland says, no, I never said he's not my attorney. I said I haven't talked to him. And once again, the conversation was not recorded. So here's another issue. Copeland represents, if he's lying, oh well, he gonna lie against you like he gonna lie against everybody else. That's what you accepted. You accepted that he was a liar and it was of no consequence to you, Ms. Hilton. But now he's saying against you that he never told you that he's not my attorney. He said that he had not spoken with Melnick. Those two things does not mean that you get to talk to him without representation. Quite honestly, you should have never approached him. If you had appearance of Melnick being his attorney in the past for other matters, you would call Melnick to determine if they still had attorney-client relations prior to trying to get statements out of him. And then Ms. Hilton says, you said he's not your attorney. You haven't talked to him. Then we continue to have a conversation. At no point did you ever say to us, hey, I want Mr. Melnick here. Hey, put Mr. Melnick on the phone. Mr. Copeland says, you didn't make me feel like I needed him. But if you needed him, we would have said, if you shoulda, coulda, woulda. No, this is why you don't talk to a witness without their attorney and not have it recorded that they have stated they don't have an attorney. So now it's your word against his. And there are records, if I'm not mistaken, where Melnick has appeared as his attorney. potentially in other cases, but you know he has had him as a representative of him in the past. So that's why you clear with Melnick's office first. Do you represent Mr. Copeland in this matter? Does your retainer extend to this particular matter? Because we need to have a conversation with him as a. So, ladies and gentlemen, we have finally found where the only part about Copeland's in the room and the only part about Copeland's safety comes into play here. Let's take it. Copeland's in the room. In the beginning of the ex parte, he's not. During this time, he is. So Mr. Copeland has noted, well, I want to speak to you personally that I have never been truthful a day in my life until I just made this statement right now. I don't comprehend none of this stuff that's going on. That's the first statement he makes to the judge, the first statement he makes on the record, the first statement once he comes into the room. I have never been truthful a day in my life. It's his first statement. Very much necessary for the defense to know. This is very substantive. So though Judge Krause's order says there was nothing substantive spoken, is obviously a lie. This is number one substantive. I have never been truthful a day in my life. First words out of his mouth. Now let's get into some more substantive stuff. The court, okay? Well, the only thing you can give is truthful testimony. Whatever you know is whatever you know. I mean, that's it. Miss Hilton. And what we'll say, and Mr. Copeland and I, we have talked about this. We found out they've done some talking outside of the presence of his attorney. But anyway, Hilton furthers, I'm not sure what your concerns are. What concerns that you expressed to Mr. Melnick last week? I know those things. I'm not familiar. I'm not sure why you're concerned. I'm not sure what you told your attorney as to why you're concerned. But if any of your concerns deal with being locked up for anything, you can't. Like there's nothing that can happen. The feds, Ms. Bumpus, well, that's not, Ms. Hilton, it is true. All that talking over each other, Ms. Bumpus, no. I said that's not his concern. Though Hilton, Hilton has a problem representing the feds. I mean, that's a reach, isn't she just the state prosecution? How does she know what the feds can and cannot charge him with? Okay. So Bumpus reiterates, no, that's not his concern. Being locked up for anything is not his concern. Ms. Hilton, if his concern is safety, we need to know that. Like that's not expressed. So we don't know what the concern is so that we can try to resolve the concern. That is what I am saying. Mr. Copeland and I have had conversations before. I understand some of his concerns are potential criminal liability. Hence is why I gave him immunity. The federal statute of limitations, done. The state statute of limitations, done. So there is nothing. Like I researched it this weekend, again, both those statute of limitations for what you and I talked about, which was in 2015 or before, done. You cannot be prosecuted for anything you testify federally or statewide. Immune, period. So if that is the concern, there is none because you cannot be prosecuted. Federal statute of limitations is 5 years. So anything from 2015, 5 years would have been 2020. Anything statewide is 4 years. It would have been 2019. Finished. Next concern, what may happen in the street? You know what we have talked about, what we can do as far as living and all that. We have had those conversations. So I'm trying to express to you, we do not want you locked up. I don't know how many times I have got to tell you that. What I've got to say to you, we do not want you sitting in the cab or wherever they got you because of this. I know you wanted to talk to me on Friday before you walked into court. We weren't able to talk. If you still want to talk with or without Ms. Bumpus, I'm here. But we do not want you in custody. So the prosecution, once again, is encouraging Woody, the witness, to have a conversation without his counsel. This is Ms. Bumpus, the standing counsel. So if you want to talk to me without her, I'm here. You will not, this order, I don't know if you kept your copy of the order, but this order says you are immune from prosecution. Any of it, literally, judge, you might want to close your ears. You confess to a murder on the stand. If we don't have any other independent evidence outside of what you say on the stand, you are immune from prosecution from what you say in court. So again, I don't know what was communicated to you on Friday. I have no idea. But what the state has assured you, which I have assured you in our private conversations, more than one, with Mr. Long. It's not Melnick. That's not his attorney. That's not Bumpus. That's not his stand-in attorney. I think Mr. Long is an investigator, but whatever, whoever he is. As I am saying in front of Ms. Bumpus, as I told you, that is what the order says. And that is direct cross-examination, meaning whatever you say on direct and whatever you say on cross-examination. Ms. Hilton, that is direct cross-examination. And then the court comes in. And Mr. Copeland, I got family members watching this trial. I don't want my nephew and them to hear these things that I may be involved in and think it's okay. So you get into that. Not once does Copeland say, I'm not safe. She alludes to, and I'm being generous, it sounds like she alludes to putting him in, you call that witness protection, what may happen in the street. You know what we talked about, what we can do as far as living and all of that. That typically means protection or, witness protection. But he never proclaims that he needs that. He never proclaims that he's fearful. And in fact, Ms. Hilton double downs and says, if Copeland's concern is safety, we need to know. Because that's not expressed. We don't know what the concern is so that we can try to resolve the concern. So that emergency call, that because of safety, is he safe? Does he feel safe? No. Hilton comes in. We need to know if it's something concerning safety because that has not been expressed. We don't know what the concern is. When we get down into the concern is he wants to plead the fifth. He doesn't want his crimes to incriminate him, and he doesn't want his crimes televised for the children in his life. Nephew number is the one he identifies to be made aware of his crimes. So he is like, look, I'll talk to you about other stuff, but just not about the crimes that I did. I want to plead the fifth on my crimes. And they say, no, there's no pleading the fifth on any crimes. You have to tell it all. And what do you know? What does he tell? On page 51, Mr. Bumpus, you've got to make a decision. So if he starts testifying today, he's going to go home today, Ms. Hilton. He should, so long as he remains. But if you get up there and be like, if you get to testifying and then you get into it, it's a lot of words she doesn't like defining, huh? You get into it and you start saying, I guess if you get into your testimony, probably that's probably the definition of it here. And you start saying, I plead the fifth. We're going to be back here again, meaning jail, Ms. Bumpus. But if he says he don't recall to everything, he'll be okay, Ms. Hilton. I'm not advising that, which is interesting that you're advising him at all, because he's represented by counsel. But anyway, but so long as he answers the questions, that's fine. So long as I did these crimes. I'm telling you that. So, Mr. Copeland, immunity deal on the table, preventing him from pleading the fifth. He wants to plead the fifth. He wants to plead the fifth to whatever crimes he may have committed. You don't know what he did. You don't know what happened. He knows more than you because he's lied to all of the detectives about his involvement so that he could pretend like he had no involvement because he doesn't want to go to jail. And at the end of the day, on page 51, he says to you, while y'all keep talking about him not being able to plead the fifth and all he has to do is say, I don't recall. He tells you, I did these crimes. I'm telling you that. And supposedly, the next statement is, okay, I don't know what you're talking about, but that's the response you have naturally. Is that, I think a natural response is, what crimes are you talking about, sir? What crimes are you saying you did? And she doesn't want to say that because what he probably wants to say is he did the crimes for which she wants to pin on somebody else. And Ms. Bumpus says, I think, are you saying you want to get up there on the stand and say something? And supposedly he has no response. I have a question. This is not substantive. This is not reflecting his testimony. This does not have any bearing on the potential objections or cross-examination that the defendants would have with this particular set of information. I want to plead the fifth. You don't know what I did. I need to plead the fifth just for the things that incriminate me. I'm trying to tell you, you don't know what happened. I've lied all the time about everything else. I don't have no way of knowing what I said before this was a lie, but I need to plead the fifth. I want to plead the fifth. I don't want this immunity deal. Look, I did these crimes. This is what I'm trying to tell you. And responsibly, you say, I don't know what you're talking about. So this supposed no response could have been a look, could have been body language, could have been an indicator, or could have been absolutely no response. Interesting enough, the next thing is said, do we find out if you could talk to his family? They just move on. They just move on and on and on. Until we get into the part where he says, the court asks, is it your desire to give testimony today? And Mr. Copeland says, yes, sir. So we got into this rabbit hole because Ryan Steele said the law requires that once the motion to recuse is in fact found to be legitimate and is ordered to recuse a judge, any rulings or activity that deny the first motion, all that activity behind that needs to stop and cease, because basically he was improperly ruling because he should have been recused back when Weinstein said so. I am concerned that the conversation is going to get into the order actually approves the ex parte hearing. The order actually states that the actions during the ex parte hearing were proper and of no substance. That's what the order said. That's why I say it's like clearly washing hands. And the only issue for necessary recusal is this defense of self. And it makes me wonder, because I don't think Judge Lanville is an imbecile. I don't care what missteps he may have had during this trial. I think he's a very highly educated individual that is aware that you're not allowed to argue. That's what I think. Because I think that because, well, at some point he read Rule 25. At some point he read it and got down to the heart of the matter, the fact that the motions have legs to stand on. So this lawyering that's getting ready to happen on this issue is going to be artful, and I'm very intrigued by it. So we shall see what happens. Tuesday shall be a very informative day when it comes down to Brian Steele's motion that he's proposed to put on the floor, which is that basically Copeland's testimony passed, I think the 5th. My age is, I think, the 5th. That testimony should be erased. And then I look forward to the other motion that's going to be a little more poignant, because that erase kind of like would mean we got to start that all over, which is reasonable. There's a reasonable argument that Brian Steele could probably land on, the fact that he was unable to fully object to the testimony of Copeland and to participate and protect his client's interests, because he was not aware of all this substantive information that came out in the transcript. But if Judge Page is going to uphold previous rulings, she very well may say, well, Judge Krause found that there was no substance in the ex parte, so we don't need to not retry, but have Copeland start over. He's already on the stand, so let's just put him on the stand and we can start from here. Now you know what you know, and let's move it along. She might say that. So then it'll be interesting to hear the other attorney's argument about how he is inadmissible due to him being a co-conspirator, and the evidence that, or most of the evidence, or some of the evidence, whatever the evidence, that he presents his own statements. Because remember, what they do is go into impeaching him by using his recorded statements about what he says happened beforehand. But if he's a co-conspirator, what he says is hearsay, and you have to corroborate that with independent evidence in order for it to stand up. So we'll see. We're going to have fun. We're getting ready to see some very artful legalese, and this is for the legal nerds that are like, give me the law, I want to know the law. And we'll probably have some very funny moments and entertainment for those of you who are just saying, how is this case still going on? I'm Lyric Armstrong, your real estate agent advocate, as well as your paralegal commentator. Appreciate you. And I shall see you in the next video. If you don't know, I'm tired. Case has got me hooked, though. I'm almost in the boat. They're going to skin me alive and fillet me and fry me up. I'm almost in the boat. I'm hooked. But one day I'm hoping that I can shake off. But until then, I will see you at the next video. Enjoy, hydrate, and see you later.